Hello everyone, this is Travel Tree News, bringing you a critical alert you'll want to hear, whether you're a visa holder, a green card holder, or planning to apply for citizenship in the United States. Imagine this: you've lived in the US for years, worked hard, played by the rules, but one past mistake, a simple DUI, driving under the influence, from years ago, suddenly puts your legal future in jeopardy. It's not just an upset, it could mean denial of your status, deportation, or blocked path to American citizenship. Sounds extreme? It's closer than many realize. Big changes are stirring in U.S. immigration law. In Washington, lawmakers are moving to pass legislation that would reshape how DUI, driving under the influence, offenses are treated for non-citizens, and these changes could affect millions: lawful permanent residents, green card holders, temporary visa status holders, and those waiting to adjust or naturalize. For many, the assumption has long been that so long as you steer clear of serious criminal behavior, your immigration status is relatively secure. But under the proposed change, that safety net may vanish. Today we break down what you need to know about this new rule, how it's different from existing law, who it affects, what you should do if you have a previous DUI, driving under the influence, and how to protect your immigration path. Stay tuned, this affects lives, families, and futures. 1. What's the rule change being proposed? A bill titled the Protect Our Communities from DUIs, Driving Under the Influence, Act, H.R. 875, has passed the U.S. House of Representatives and is now under review in the Senate. Here are the headline changes. The bill would amend the Immigration and Nationality Act, INA, to add a new ground of inadmissibility for any non-citizen who has been convicted of, or admits to committing, a DUI, or similar offense, regardless of whether it is classified as a misdemeanor or felony under state, tribal, or local law. It would also add a new ground of deportability, removability, under the INA for non-citizens with DUI convictions or admissions. Importantly, the legislation covers admissions of conduct, meaning even if someone says, "I drove after drinking," even without a formal conviction, they could potentially be impacted. Distinctions such as state law classification, misdemeanor versus felony, would no longer matter. What matters is the essential elements of the DUI offense under the jurisdiction where it occurred. In short, the proposed law dramatically lowers the threshold for immigration enforcement related to drinking and driving behavior, from serious DUI, driving under the influence, with aggravating factors, to any DUI, driving under the influence, or admission of it, across all visa/immigration categories. 2. How is this different from current U.S. law? Under current law, a single DUI, driving under the influence, conviction does not automatically render a non-citizen inadmissible or deportable. Instead, a DUI may qualify as a crime involving moral turpitude, CMT, or other removable offense only if the facts are serious, e.g., bodily injury, serious vehicular harm, aggravated elements. Immigration consequences often depend on how the state classifies the offense, felony versus misdemeanor, and whether there are other factors like child endangerment, license suspension, etc. Many immigrants with a single DUI, especially a misdemeanor, have been able to adjust status, renew visas, or naturalize without deportation automatically triggered. With the proposed changes, that status quo would shift. The bill would make all DUI convictions/admissions ground for removability or denial, irrespective of classification, and with limited discretion. In other words, what was once a state-level traffic or criminal offense becomes a federal immigration trigger. 3. Who will be impacted by this rule? Here's how it breaks down. Green card holders, lawful permanent residents, LPRs. Even long-standing LPRs with single-incident DUI convictions could face new deportation risk or finding of inadmissibility if they seek some immigration benefit, renewal, adjustment. Visa holders and non-immigrant status holders. Students, workers, temporary visa holders may face visa revocation, denial of renewal, or removal based on DUI admissions or convictions. Citizenship applicants. The path to U.S. citizenship typically requires demonstration of good moral character. Under the proposed law, a DUI conviction/admission could disqualify an applicant. Those seeking to enter or re-enter the U.S., for those applying for visas abroad or re-entering, a past DUI might render a person inadmissible, not allowed to enter or adjust status. Families of immigrants, because a parent's or a spouse's status depends on the primary applicant's immigration status, the ripple effect can touch entire families. Importantly, the bill language does not clearly state whether it will be retroactive, i.e., apply to DUIs that occurred years ago, before the law's enactment. Some legal commentary suggests that because immigration law is civil in nature, past incidents could be subject to review. Either way, many legal practitioners are advising caution. 4. What the bill's supporters versus opponents say. Supporters argue. This is about public safety. DUI crashes cause thousands of deaths and injuries each year, making DUI behavior an explicit ground for removal strengthens accountability. They maintain that non-citizens must adhere to high standards of conduct if they wish to remain in the United States, especially as lawful residents. They believe the change provides clearer, uniform rules across states, versus patchwork state laws, and makes immigration enforcement more consistent. Opponents warn. The law may be overly punitive. It treats a single, possibly minor DUI, driving under the influence, even a misdemeanor, the same as a serious criminal offense, with little discretion. It could disproportionately affect immigrant communities who may have made one mistake years ago and otherwise led law-abiding lives. The lack of clear retroactivity language raises concerns of fairness and due process. Some fear it might deter individuals from reporting incidents or seeking help, for example, driving under the influence interventions, for fear of immigration consequences. 5. What should you do if you have a past, driving under the influence, or fear you might? If you are a non-citizen living in the United States, whether on a visa, green card, or seeking citizenship, here are some actionable steps. Seek qualified immigration counsel. Laws like this can be complex, and you'll want a lawyer with both immigration and criminal law experience to assess your specific case. Review your record. Even DUIs, driving under the influence, you thought were minor or resolved could carry immigration consequences. Be aware of arrests, pleas, convictions, admissions of conduct. Avoid travel risk. If you have a driving under the influence history and hold a green card or visa, traveling overseas to re-enter the U.S. may carry risk of secondary inspection, inadmissibility findings, and even detention. Some community stories cite people being questioned at border re-entry due to old, driving under the influence, charges. If you are applying for citizenship or adjustment of status, be extra cautious. The good moral character requirement could be jeopardized. Make sure you disclose all relevant information and consult your lawyer before filing. Don't assume immunity because your driving under the influence DUI seems minor. Under the proposed law, even misdemeanors and pleas may trigger immigration consequences. Stay updated on the status of the bill. Because the bill is not yet final law, things could change. But it's wise to prepare as though changes could be enacted. 6. What's the status of the bill right now? H.R. 875 passed the House of Representatives 246-160 on June 26, 2025. The bill is now with the Senate Judiciary Committee and awaits further action. Because it has not yet been signed into law, enforcement under this bill is not yet active, but many believe the changes are likely to pass or prompt similar regulatory action. Even before formal law, some non-citizens are already receiving increased scrutiny based on DUI histories and visa/immigration risks. So while the rule is not yet final, the environment is evolving. 7. Why this matters for you, and millions of others. If you're a non-citizen living in the U.S., this proposed rule represents a game-changer. Here's why. The margin for error is getting smaller, whereas once a single DUI, driving under the influence, might have had limited immigration consequences, under the new regime it may become a major hurdle or removal trigger. It affects long-term residents, many green card holders assumed stability. Now even old offenses could threaten their status. It undermines assumptions about good moral character. If you were planning to naturalize, a DUI, driving under the influence, conviction or admission may now block that path. It increases the importance of full disclosure and legal review. Free consultations today could prevent major problems tomorrow. Families and communities may be impacted. The consequences are not just personal, they affect dependents, spouses, children, travel plans, and future opportunities. In short, this shift sends a message that for non-citizens, citizenship, or full lawful status, will be the only absolutely secure status, and everything else will require stringent compliance with the law. 8. Final thoughts. We're at a turning point in U.S. immigration policy. While modernization and efficiency reforms are welcomed, the enforcement expansions tied into this bill should not be overlooked. For many in the immigrant community, it will no longer be enough to stay under the radar or assume that a single past mistake won't matter. The proposed rule demands flawless compliance, or else. If you or someone you know has a DUI record, or even an admission, act now. Consult a reputable immigration attorney, review your options, consider urgency for citizenship or status adjustments, and stay informed. The margin for error is narrowing. From Travel Tree News, we'll keep watching this story closely and bring updates as they unfold. Your future could depend on staying ahead of these changes. Don't forget to support us by subscribing to our channel Travel Tree News. Thank you for joining us for this important alert. If you found this useful, please share this update so others in your network can stay informed. We'll continue to provide professional, factual, and timely coverage of U.S. immigration developments. Stay informed. Stay safe.